Hello, I'm J. Jermaine Bay with Elonium Moris Pradium, Ante, Colorado. The acronym is AMPAC. I'm the Chief Judge of Consular Court. Today is class number 90. Class 90. What did we learn in class 89? Well, we're still going over the Charter of the United Nations of 1945, Chapter 6, right? It's about the Pacific Settlement of Dispute. And right now the Moors are learning how to deal with disputes, not only disputes amongst ourselves as having Moroccan states, right? Because we got to maintain peace amongst the Moroccan states. How do we come together? But at the same time, how do we deal with a dispute with the United States of America as well as the United States International Organization or one of their several chartered dependent states? How do we deal with that? Well, according to international law, you must seek a peaceful means of dealing with that dispute. What does that mean? You have to be competent with your pen. You have to understand what's called a political settlement versus a judicial settlement. So when you're reading the Charter of the United Nations, Article 33 talks about mainly a political settlement, right? So what's the political settlement? That's mediation and then arbitration, right? After that, if you can't settle it peacefully after that, who's up next? Judicial settlement. So it's two parts of law. You have political law and then you got judicial law. Judicial comes in to finalize it based upon justice. Because in any dispute, that dispute must be settled. You cannot allow it to fester, right? So if two parties are serious, they will allow a third-party judge to come in and settle the dispute if they're serious, right? And this is what Moors have to learn. We have to first learn how to use our pen with politics. And from there, if politics does not prevail, then justice must prevail, right? So according to our treaties, how does judicial prevail? What's called consular court. But if our consular courts do not prevail in dealing with the United States of America and the international organization commonly known as the United States, what do we do next? We have to maintain the peace. We have to now petition the United Nations and their organs. And one of their organs is the ICJ. What's another organ? Well, that's the General Assembly. You got the Security Council, as well as you got human rights committees, etc., right? All there's several organs. And this is what Moors are learning, okay? So class 89 is really to get the Moors to start understanding that the United States understands the step-by-step process in terms of dealing with Erga Omnes parties, right? The United States understands what it is to write a declaration of intervention, which means the Moors have to learn how to do this as well. The Moors have to understand the political steps to achieving peace and security. The Moors have to now understand the judicial steps to maintain peace and security, all right? Because everything must be settled based upon justice, right? No justice, no peace, right? So that means things need to be settled. You can't have peace because there's been no justice in the United States for who? Moorish subjects. We're not straw men. We're not Moorish Americans. We're not African Americans. Who is not getting justice right now? It is Moorish subjects who need to return back to Morocco and get protections under Moroccan law. That's what we must understand. And until then, the Moors will never get justice until you have your own self-determination and self-governance along with your own people to seek justice. You must justify the justice by returning back home, Dorothy. Until then, you'll remain with the Wizard of Oz, right? Okay, let's go ahead and jump on the class. So, you know, AMPAC opens up the Constitution. The Constitution is paramount. But what does the Constitution really serve in this political game of chess, right? Because everything we're doing right now, we're starting to move our pen in combination. We're writing different documentations, right? We're writing different type of Constitution. The Constitution is what? It is the chessboard itself, right? It is the launching pad, right? It's the spring board of chess. Without the Constitution, there is no chess. You've never seen anybody play chess without chessboard. So the Constitution represents the chessboard itself. It is the springboard where everything begins. It's paramount. It's first. It's primary. It sets forth the proper written instrument with your pen. Without the Constitution, there is no Erga Omnes parties. Without the Constitution, there is no declaration of intervention. Without the Constitution, there is no consanguinity. Without the Constitution, there is no estate. Without the Constitution, there is no deed. Without the Constitution, there is no trust. Without the Constitution, there is no will. Without the Constitution, the people cease to exist, because that means you're stateless. And if you're stateless, that means you're an alien, because no state representing the mother, a constitution is mother. The mother has not proclaimed and claimed her own children yet. You're stateless. And if you're stateless, that means another state has to adopt you. And the United States adopted all of the Moorish subjects in 1868 under the 14th Amendment and turned all the Moorish subjects into citizens of the United States of America, because we did not have our own state that was recognizing us as its children. So under that adoption agency legislation of their constitution, they put it in their constitution because they were playing political chess. And once they put us into the 14th Amendment, after that, they made us bound to what next? Their civil and criminal courts. You see? So first it's political, then it becomes judicial. Because they could not allow Dred Scott in 1857 to utilize their courts. Why? Because he wasn't a citizen of the United States of America. He was simply stateless because Morocco was not claiming Dred Scott, because Dred Scott did not know that he was what? Moroccan. The parties must be known. So he was seeking help from the United States of America. The same way the Moorish Americans are doing right now. They're seeking the United States of America just like Dred Scott was doing. Because the Moorish Americans think they're Americans, and Dred Scott thought he was American until he found out through the Supreme Court that Justice Taney said, no, you're not American. You can't be a citizen because you are a Moorish subject according to the treaties. And you got to go back and petition Consular Court of Morocco. So therefore, all the Moors, all this time ever since 1857 Dred Scott case, all the way up until now the 21st century, every last Moorish subject is Dred Scott. Until you return to Morocco to be recognized by your mother. And the mother is the Constitution. And right now your stepmom is called the Constitution of the United States. That's your stepmom. But once you return home to your real mother, your mother will recognize you with a pen and allow you to pledge your allegiance back to the family. Back to your mother will look at you and say, you are a long lost sons and daughters. You have to return back home through an application and renounce and denounce the United States stepmom Constitution. That's the truth. All right? Let's go ahead and get into the class. Okay, so the Moors know right now we're in, this is the Charter of the United Nations of 1945, Chapter 6, about the Pacific Settlement Disputes. We've been taking a deep dive into Article 33. Right now the Moors are learning how to come together as one state. Right? So one Moroccan state is being infringed upon its rights, right? The integrity of the domain is being infringed upon by the United States of America, the United States, or any one of their several charter-dependent states. All the Moroccan states can come together and petition the International Court of Justice and act like one state. So in the meantime, the Moors are thinking about putting together the Constitution of the United States of Morocco, right? But in the interim, what do? How can we still come together as one state? What's called Erga Omnes parties. But we must write what's called a Declaration of Intervention in order for us now to be recognized as being also a party to that same suit, right? Commonly known as a class action lawsuit, but in international law it's called an Erga Omnes parties, okay? So we'll keep taking a deep dive. Like I told the Moors, we're going to stay on this post, right, of Chapter 6 for a while, because it's one of the most important chapters of the Charter, okay? All right, so as the Moors already know, the last few classes we went over the Erga Omnes parties document, right? This document here, we read this is Erga Omnes parties before the International Court of Justice from standing to judgment on the merits. So we read through all of this, right? So we got a basic understanding of this was a law review by the barristers, right? By the attorneys, by the lawyers who were taking a look at ICJ proceedings. What is it that a state has to do in order to become an Erga Omnes party? How they can become an Erga Omnes party, and what are the pathway to be successful at being an Erga Omnes party, right? So more should go back and read this and add this to your file as a reference point, because these attorneys gave a lot of answers to the test. One of the major themes they talked about is documentary evidence, right? It's all about documents, Morris. Well, how are we ever going to have documents if we're not writing them ourselves in a competent way? The next thing this document pointed out was what? That the ICJ is going to petition to take a look at our consular court orders, right? And what else? We learned that the ICJ has the power to even come directly to the site of the incident in order to collect evidence. We also learned that the ICJ can petition for the Security Council to put together an investigation committee to come and take an investigation into a territory where there's been alleged crimes, right? So basically, we've all heard of what the FBI, right? Federal Bureau of Investigators. Well, guess what? The United Nations also put together what they call a special agreement for investigators of the United Nations. It would be called the UNI, right? United Nations investigators, like the FBI, Federal Bureau of Investigators. United Nations has the same powers. UNI, United Nations investigators. And one of these days, guess what, Morris? Guess what we're going to have? That's what we're going to have. The MBI, the Moorish Bureau Investigators. We'll have our own investigators, right? So you must always project, Morris, onwards to understand where we want to be. All of our brothers and sisters right now that work at the FBI, DEA, CIA, all the alphabet boys, our people are being trained. And sooner or later, they will come back home and they will represent us. They'll bring back that subject matter expert that they've learned from the United States. They'll bring that benefit back home eventually. And they will assist us, right? So that's what we got to understand, Morris. So we went through this document. Okay, you go back to the other classes. Okay, and it was about preparing us now to start understanding about the Declaration of Intervention. So in the previous classes, we started learning about this Ukraine versus Russia case, right, of the ICJ. It was allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russia Federation, in the year 2022 inter alia, right? So we learned that all of these European states came together under what's called a Declaration of Intervention, right? They all wrote a letter. We'll talk about that. We'll keep learning about what exactly is a Declaration of Intervention. But look at all these European states. This will be the Moors. Eventually, we will more than likely end up with, 50 plus Moroccan states. Imagine that. Imagine all these same Moroccan states right here as Erga Omnes parties to this lawsuit, right? So right now, these are European states, but eventually, this will be the same way the Moroccan states will look, okay? All right, so we're learning about this whole list, okay? So as you come down, you'll see that the United States of America wrote a Declaration of Intervention as well, right? So if you click on that, this will take you directly to the actual letter that they wrote, okay? So that letter, once you open it, it will look like this, okay? The beginning of it will look like this. It'll say International Court of Justice, okay? It'll say allegations of genocide under the Convention of the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russia Federation. So the United States of America wrote this, right? They wrote a Declaration of Intervention under Article 63 of the Statute of the International Court of Justice. We'll talk about that today, Article 63. Submitted by the United States of America. That's the document, right? Now it's 26 pages. We won't read it today. We're going to read it in the next class, all right? But I wanted to give the Moors a snapshot real quick of where we're going with this. We're going to read the United States Declaration of Intervention. That way we get an understanding of how they wrote it, okay? All right. But today, what we'll do is we're going to learn more about the introduction of intervention under international law. Okay, we'll take a look at how attorneys review international declarations, all right? Intervention declarations, I should say, right? So I've showed this image before. This is a document. It's about 12 pages. We're going to read that today, all right? So we'll dive in just to get a basic understanding and see how attorneys look at what's called a declaration of intervention, or intervention as a single word in itself, just intervention as a word, right? When states get involved with other disputes. We'll read that today. But before we do that, let's take a look at a preview of what the International Court of Justice says in their handbook, right? So more should already have this as a reference point in their file, right? So these are reference points. So in this particular handbook, if I go to Control F and I type in the word intervention, right? Intervention. Here's what you get, okay? So intervention. So the word intervention is in the handbook, okay? It's one of the chapters. It's highlighted. It's in red, right? So they went into this with a little bit deeper dive, okay? So let's go ahead and read a little bit, get a basic understanding from how the ICJ sees intervention in their handbook, all right? Okay, no, let's go ahead and start reading.
Intervention. The statute of the court, Article 62, makes it possible for a state to intervene in a dispute between other states so as to protect itself against the possible effects of a decision in which it has not been involved, when it considers that it has an interest of a legal nature which may be affected by the decision in the dispute between those states.
Pause. Okay, let's read that first sentence again. The statute of the courts, Article 62, makes it possible for a state, capital S, to intervene in a dispute between other states so as to protect itself against the possible effects of a decision in which it has not been involved, when it considers that it has an interest of a legal nature which may be affected by the decision and the dispute between those states. Okay, so the ICJ is already pointing out the reference point where states can utilize Erga Omnes parties. Well, states can use the Declaration of Intervention. And which article is that? It's Article 62. Okay? So let's go ahead and click on that now so we have a basic understanding of Article 62 and Article 63, so the more start understanding that we're moving based upon following a set of instructions. So when we're reading this, read this as, okay, the ICJ is telling us how to win. They say you Moors need to use Article 62. And we'll also read Article 63. This is how you read the handbook. It gives you the answers to the test. Okay? So let's go ahead and back to the charter. Let's go to the charter. Or should I say, we're going to read the statute of the International Court of Justice. Isn't that what the ICJ said? It said go back and look at the statute, right? So let's go back to the letter. Let's go back to the letter, to the handbook. It said the statute of the court, Article 62. So you don't go to the charter, you go to the ICJ statute, okay? Let's take a look at that. So this is the statute, okay? Boys can look this information up, okay? So the statute is an addendum, is an appendix to the charter. There is no charter without the ICJ statute. There's no ICJ statute without the charter. They're one and the same. They're an appendix, an addendum of each other, okay? So you've got a master contract, which is the charter, right? And then you've got an addendum. That must be the understanding, okay? So the statute of the International Court of Justice. Nova, can you read Article 1 for me, please?
Article 1, the International Court of Justice, established by the Charter of the United Nations as the principal judicial organ of the United Nations, shall be constituted and shall function in accordance with the provisions of the present statute.
Okay, so they're one and the same. Okay, they're appendix of each other. Okay, so now we're going to go down to Control F. We'll put in the word, we'll put in 62. Let's go to Article 62. Okay, we're going to read Article 62 and Article 63 to get an understanding. And why is the ICJ pointing out this article, right, in their handbook? Okay, no.
Article 62, 1. Should a state consider that it has an interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. 2. It shall be for the court to decide upon this request.
Okay, so in Article 62, should a state consider that it has an interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene, such as Ukraine versus Russia. Now, Russia wasn't attacking the United States International Organization. Russia was attacking Ukraine, but the other European states decided to get involved. Why? Because they had an interest in what was going on in Ukraine, right? So they had an interest in what was going on, an interest of a legal nature, right? But what made it a legal nature for them to get involved with Ukraine? Well, it's because they're investing in Ukraine. The other European states are investing in Ukraine. But do they have a contract with Ukraine? So Ukraine is not a party to NATO. And Ukraine is not a party to the EU, right? European Union. But yet, Ukraine is purchasing what? Weapons from the other European states. That's the legal nature, because there's contracts involved, right? That's how they're tying it in. They're looking out for another European state. But what truly is a legal nature? What are they trying to say here? Right? So before we dive into what's called a legal nature, I got that highlighted for a reason. We're going to read Article 63 real quick. Okay, Article 63.
Article 63, 1. Whenever the construction of a convention to which states other than those concerned in the case are parties is in question, the registrar shall notify all such states forthwith. 2. Every state so notified has the right to intervene in the proceedings, but if it uses this right, the construction given by the judgment will be equally binding upon it.
Okay, that's very important to understand. So when the Moors come together as Erga Omnes parties to the suit, just like that long list I showed you of European states supporting Ukraine, whatever judgment comes out of the International Court of Justice for Ukraine or against Ukraine is also applicable to all those European states, because they become one party on the suit. That's what a class action lawsuit is. You're acting as one party, even though it may be 50 or 100, 300, 1,000 people to the suit. The suit is really one party, right? One party, which means all of y'all get the same decision. So when the Moors go to the ICJ, we'll go technically as one party, even though we have a long list of Moroccan states. This is how we come together and we unite, right, as Erga Omnes parties. Well, we must all write a letter of declaration of intervention. Okay, we'll learn more about that. All right, so let's go back to what I was saying about Article 62 and 63. So in 63 it says, whenever the construction of convention to which states other than those concerned in the case of parties is in question, the registrar shall notify all such states forthwith. So how is it the registrar of the ICJ, who are they supposed to notify that's also potentially has an interest in the case, such as Ukraine? How is the registrar of the ICJ, who was they supposed to contact that was down with Ukraine? Well, that means that other parties must have already been a part of some type of legal nature or contract of some sort for the registrar to identify who else has an interest in the case, an interest, a legal nature, right? Now let's go back to 62. This is very important for the Moors to understand what I'm about to explain to you, so please pay close attention. Okay, first let's go back to the ICJ handbook. The ICJ is trying to tell you something. In the ICJ handbook, the statute of the court, Article 62, makes it possible for a state to intervene in a dispute between other states so as to protect itself against the possible effects of a decision in which it has not been involved. when it considers that it has an interest of a legal nature, which may be affected by the decision in the dispute between those states. We're talking legal nature. What makes Moors have a legal nature between our Moroccan states? Right now, Moroccan states are saying, yeah, we're going to come together as Erga Omnes parties to a suit. But what is it that we all have in common, other than the fact we're Moors and we're Moroccans and we have states? What do we have that binds us together at this time? Nothing. We're all autonomous states. So we need a legal document that creates a legal nature, that creates an interest for the fact that all of us can come together. And what do we need at this time? Okay, listen. All right, let's go back to the chart. To the International Court of Justice, Article 62. We got to create a legal nature. That way we have a vested interest together under the legal nature. What should be that legal nature? Here we go. Right now, we as Moroccan states are drafting a convention amongst the Moroccan states. This creates the legal nature that binds us together through a contract. Now we have a right to say any infraction against one of our brethren or sister states is an attack on us as well, or all of us. You attack one of us, you've attacked all of us. Well, that sounds good. How do you prove that? You need a contract that says that in advance. So right now we're putting together the draft articles to establish a convention in the Empire of Morocco for the Wazir Regional Council. All the heads of state will sit at this round table to represent all the states, but all the Moroccan states will sign this as a contract that creates a legal nature that binds us together to look out for each other. Right? See right here? It says, we, the competent Moors of the Empire of Morocco, do hereby establish a multilateral convention. What does multilateral mean? All of us coming together under this convention, i.e. covenant. Right? By the member states, now we're member states, parties to the convention, and have combined our efforts to reign in the order of unity and accountability throughout the Moorish Empire. Let's read it again. We, the competent Moors of the Empire of Morocco, do hereby establish a multilateral convention by the member states, parties to the convention, and have combined our efforts to reign in the order of unity and accountability throughout the Moorish Empire. You see that? So immediately, as soon as you start reading, it's got the word convention. Oh, the international world knows about the word convention. That's an international law word, right? Then we got on here, we're talking about the fact that we're parties to this contract, as members to this contract creates a legal nature. But what else? Okay, let's go Control F. You put in the word intervention. You see what happens? It popped up, right? This is the preamble. Preamble of the convention. Right here it says, emphasizing that the combined efforts of states to any dispute can be expressed through a joint declaration of intervention as Erga Omnes parties to help unite our efforts for the common defense of our interdependent states. You see, it's already in the contract, which gives us a right already to invoke a declaration of intervention. That creates the legal nature that we've already signed it in advance. This is high-level thinking. This is next-level thinking of how the Moors can come together, because let's just be honest. All the Moors have been taught for the past 100 years to do this as an individual Moor. Go against the United States and their magistrates and their courts and their de facto this and de facto. We went against them one at a time. One at a time. And we were getting defeated. You must move your chess pieces, Moors. You got to move your chess pieces in combination. No one pawn can defeat the United States. Thus the reason why you start off with 16 pieces. It's a group-on-group dispute. So the Moors all the time have been taught to go out there and be one lone Moor. And this is why we've been losing. Nor can we be one lone state. We must come together under multilateral contracts to combine our efforts to unite in order to play this political game of chess. And then the next level is called judicial game of chess. There's different levels to this. And right now we're learning the political side in order to get to the judicial side, which is through our consular courts and next the ICJ. This is next level thinking. This is critical thinking. But you must move your pieces in combination, right? This is what Moors must understand. All right, so that's the purpose of the draft articles. So we're creating a legal nature. This was the ICJ is telling us, create a legal nature and use Article 62, 63. Okay, what else? Okay. The Moors right now putting together draft articles for what? For the United States of Morocco Treaty Organization. Once again, the world recognizes the word treaty. Right? You have bilateral treaties and multilateral treaties. We're putting together a multilateral treaty because that creates an Erga Omnes Parties convention. It creates a multilateral treaty that creates now an organization because the Moors have to come together and organize. It creates a legal nature of what? The state parties to the treaty. Did it say individual Moor party to the treaty? No. No individual Moor. That's the old paradigm. We got to stop doing that. We must cease and desist going at this as individuals. We must come together and unite under Erga Omnes Parties. We are stronger together. And therefore it says right here, we're creating a legal nature as state parties to the treaty. All right, so if I go to Control F, and I type in intervention, it'll drop down to Article 2. Now this is a draft article. Like I said, it's a draft article. It hasn't been fully ratified, right? It's not been put into full powers or full use in effect. It's still a draft, but we're talking about it, right? We're creating legal natures. But these are the moves we have to make, right? These documents have to move in sequential order, okay? They have to keep backing up each other. We write a constitution, then we set forth legislation, then we set forth a council court order, right? After that, what do? We petition now the United Nations and all their several different organs in the ICJ. We're moving in combination, step by step forward, right? Now look, Article 2. The parties will contribute toward the further development of peaceful and friendly international relations by strengthening their free institutions and bringing about a better understanding of the principles upon which these institutions are founded. And by promoting conditions of stability and well-being, they will seek to eliminate conflict in their international economic policies and will encourage economic collaboration between all the parties. And at the appropriate time and date, the parties shall mobilize the defense as joint parties to a declaration of intervention. It's already in the contract. It created a legal nature. You see, this is what we're doing in advance. Because we learned when we read this document right here, just a moment. When we went over this document, what did we learn in this document that the attorneys pointed out to us? Do you remember what they told us? They said, Morris, it's all about Control F. You got to put in evidence, right? So 243. It's all about evidence, Morris. What did we need? What did we learn when we read this, Morris? What did these attorneys point out to us? Okay, it says Attend cases based on Erga Omnes party standing may have for the different types of evidence, the typical feature in ICJ proceedings. We needed what? Documentary evidence. For what? Because it's the most important type of evidence. What type of evidence do we have? Okay, we've got what? We've got a convention that created a legal nature in advance to any dispute. Okay, what else do we have? What we have? We'll have Article 2 that talks about a declaration of intervention already within the draft articles of our treaty. The Moors were signed amongst the states. We're already creating documentary evidence, keeping in mind that our conventions and treaties will be deposited with the Secretary General of the United Nations so they can put it on the record. Who else will receive a copy? The United States of America and the United States International Organization, as well as any one of their several chartered states, right? They'll all be given advance notice of the documentary evidence that we have a legal nature that the Moors have combined our efforts. Let's go back to the handbook. Okay, Noah, let's take it from the top.
Okay, intervention. The statute of the court, Article 62, makes it possible for a state to intervene in a dispute between other states so as to protect itself against the possible effects of a decision in which it has not been involved, when it considers that it has an interest of a legal nature which may be affected by the decision in the dispute between those states. Any third state seeking to intervene in the case must normally file its request for permission to do so before the closure of the written proceedings in the principal case. Fiji sought permission to intervene in the nuclear test cases, as did Malta in the case concerning the continental shelf Jamboree. Italy requested permission to intervene in the case concerning the continental shelf Libyan Arab Jamboree, Malta. Nicaragua filed an application for permission to intervene in the case concerning the land, island, and maritime frontier dispute in Australia, Samoa, the Samoan Islands, the Marshall Islands, and the Federated States of Micronesia requested permission to intervene in the request for an examination of the situation in accordance with paragraph 63 of the court's judgment of 20 December of 1974. In the nuclear test of New Zealand versus France case, the Philippines sought to intervene in the case concerning sovereignty over Pulau, Ligatan, and Pulau, Sipadan, Indonesia, Malaysia, and Equatorial Guinea filed a request for permission to intervene in the case concerning the land and maritime boundary between Cameroon and Nigeria, Cameroon versus Nigeria. Honduras and El Salvador requested permission to intervene in the territorial and maritime dispute for Nicaragua versus Colombia, and Greece sought to intervene in the case concerning jurisdictional immunities of the state Germany versus Italy. Only Nicaragua, Equatorial Guinea, and Greece were successful in their applications. When permission to intervene is granted, the intervening state has received copies of the pleadings, may submit a written statement, and participate in the oral proceedings. However, it does not by that fact alone become a party to the case and cannot ask the court to recognize its own rights. On the other hand, the court has accepted that a state may intervene in the dispute and only if there exists a valid basis of jurisdiction between all the states concerned. Territorial and maritime dispute, Nicaragua versus Colombia, application by Honduras for permission to intervene. In such a case, which has yet to occur in practice, the decision of the court will be binding on the intervening state as it is on the other parties in respect with any aspects of the case on which basis the intervention was allowed.
Okay, thank you, Sister Nova. So what are we learning here? This highlighted here, that's important. Okay, so However, it does not, by the fact alone, become a party to the case. What? They're talking about what? If you write a declaration of intervention, it doesn't automatically make you a party. The ICJ has to determine what gives you the right of a legal nature to have interest, right? They have to determine where is your proper written instrument, where is your documentary evidence that says you are a party to this, one way or another. What's your connection in all of this, right? That's what they're reviewing. So it says, however, it does not, by that fact alone, become a party to the case and cannot ask the court to recognize its own rights. On the other hand, the court has accepted that a state may intervene as a party, but only if it has shown that it has an interest of a legal nature in the dispute, and only if there exists a valid basis of jurisdiction between all the states concerned. So when we go back and we fully ratify the convention, right, and we fully ratify the treaty organization, that immediately creates a legal nature. And the International Court of Justice has to accept the fact the Moors have already agreed to be a collective in any party plaintiff suit, right? And we're the respondent, if we're the claimant, if Moors are the claimant at the ICJ, we've already signed previous contracts with conventions and treaties that create a legal nature, which is a legal obligation to become what? Parties and write a declaration of intervention. That's the consequences of signing a contract. We must protect each other, right? That's what it comes down to. We're getting ahead of the game, right? We're moving our pieces in combination. That's chess, right? Okay, now look at this bottom part. It says, in such a case, and what type of case? If they allow the parties to be erga parties, which has yet to occur in practice, the decision of the court will be binding on the intervening state, as it is on the other parties, in respect of any aspects of the case in which the basis, the intervention, was allowed. So the final decision from the court is applicable in all the other Moroccan states, because we became one party. All right?
The court statute, Article 63, also stipulates that where a case appears to involve the interpretation of a multilateral convention to which states other than the applicant and respondent states are parties, the registrar is required to notify all such states forthwith, and any state so notified has a right to intervene in the proceedings.
Pause. You see what they just said?
Multilateral convention.
The court statute, Article 63, also stipulates that where a case appears to involve the interpretation of a multilateral convention to which states other than the applicant and respondent states are parties, the registrar is required to notify all such states forthwith. And any state so notified has the right to intervene in the proceedings. You see that? Because we created a legal nature. Let's continue.
A declaration of intervention may be made even though the registrar has not given such notification, and should normally be filed before the date fixed for the opening of the oral proceedings relating to the principal case. A number of states have presented declarations of intervention. Poland in the case concerning the SS Wimbledon, Cuba in the Haya de la Torre case, El Salvador in the case concerning military and paramilitary activities in and against Nicaragua, Samoa, the Solomon Islands, the Marshall Islands, and the Federated States of Micronesia with respect to the request of an examination of the situation in accordance with paragraph 63 of the court's judgment of 20 December 1974 in the nuclear tests New Zealand versus France case, and New Zealand in the case concerning Walling in the Antarctic, Australia versus Japan. The intervention was admitted in the first two cases and in the last case. The interpretation of the multilateral treaty that is given by the court in its judgment will be binding upon any party that has intervened.
Pause. Okay. This last sentence, or last two. The intervention was admitted in the first two cases, and in the last case, the interpretation, right, of the multilateral treaty that is given by the court in its judgment will be binding upon any party that has intervened. So first they mention what? A multilateral convention, then they talk about multilateral treaty, right? And this is what the Moors at this time, let's just go back. The Moors are working on a multilateral convention, and the Moors are working on a multilateral treaty. You see that? Legal nature. We're stronger together, Moors. All right? Okay, let's go back to the document.
Finally, in accordance with an amendment to Article 43 of the rules, which entered into force on 2005, the court may direct the registrar to notify any public international organization that is party to a convention, the construction of which is at issue in a case. Any public international organization so notified may then submit written observations on the particular provisions of the convention, the construction of which is in question, and supplement those orally should the court consider it necessary.
All right, so not only would the Moors have a multilateral convention, not only would we have a multilateral treaty, but guess what other word is in our treaty, right? It is the word organization. So NATO, acronym NATO, North Atlantic Treaty Organization. So the Moors now will have a multilateral treaty organization. Keep in mind that NATO is a military alliance. So the Moors will put together a military alliance treaty organization. And the International Court of Justice recognizes this, because they recognize international organizations. You see how we're following instructions? We're strengthening our position. We've got legal nature conventions, we've got legal nature treaty, we got legal nature organization. And we'll never have none of it unless we have what? Constitutions. That's the springboard. That is the chessboard. And everything after that, you're now putting together your pieces and moving your chess pieces, your political pieces. These are political documents, right? That the judicial branch is looking at your political documents. But it starts with politics. This is why in the rights of indigenous people, it says political first. The first word is political. They say you need your political, legal. Then it says economic. Political, legal, economic. Political comes first. What's political? The state. And all the boxes you need to check for your integrity of domains before you can ever get to a point of economics or judicial settlement. There is no justice without the state. And without the state, you can't become a multilateral party to nothing. All you got left is civil rights. And civil rights is for Moor subjects and not for Moroccan nationals. Let's continue. This is the ICJ handbook.
Examples of a special agreement, an application instituting proceedings, a memorial, preliminary objections, orders, and a press release may be found on the court's website, www.icj-cij.org. The official titles of cases are decided on by the ICJ are also published on the website. Written pleadings and oral arguments are published in the ICJ pleading series and are also found on the court's website. The court's decisions involving the application of its statute and rules are published each year in the ICJ yearbook.
All right, so what is the ICJ telling you here? Go back and look at case law regarding any type of infraction that you think you're dealing with. More than likely, you can go back and find some case law on the ICJ website. You can find res judicata, precedent, commonly known as repertoire, is what they call case law, right? The answers to the test is at the ICJ website for the Moors. Now, how long has the International Court of Justice statutes been in effect? Since 1946. We're in the year 2023. Why didn't the Moors know about this? But now that we know, let's get to work, right? We have to learn how to put together multilateral conventions, multilateral treaties, and multilateral conventions, right? Okay, let's continue. Now that we read over the handbook, let's go to Article 73. Let's learn a little bit more about Article 73, which, keep in mind, the United Nations Charter, because that's what we're reading right now, is a contract. The United States of America has signed this contract. They were the original signer. They were a negotiating state. What does negotiating state mean? You were there during the actual ratification, or should I say drafting of the charter, and then they were there during the original ratification of it. So they're bound to this contract, and now that Moors are establishing their states, they're restoring their states, we also have consented or acquiesced to this same contract. Whether you're a member state or a non-member state, you have still acquiesced to the provisions of the charter in order to maintain peace and security on planet Earth. This is the obligation of all states, whether you're a member state or not. Okay, so chapter 11. Okay, no, let's read that.
Chapter 11, Declaration regarding non-self-governing territories. Article 73, members of the United Nations which have or assume responsibilities for the administration of territories whose people have not yet attained a full measure of self-government recognize the principle that the interests of the inhabitants of these territories are paramount, and accept as a sacred trust the obligation to promote to the utmost within the system of international peace and security established by the present charter, the well-being of the inhabitants and these territories, and to this end. All
right, so this is an obligation of the United States of America, and guess who else's obligation? Any Moroccan state. This is a contract. We must all accede to this contract. Whether you consent by becoming a party to it, or you acquiesce by saying you're not going to consent, but you still acquiesce to it, because all state, anyone using the brand of state to represent its community of people are automatically bound to these provisions. But more importantly, the United States of America has signed it directly, right? So in this contract, it's telling you what the United States of America's obligations are to who? More subjects who are trying to choose between the entire submission to the laws of the empire. Where did I get that verbiage from?
Treaty of Madrid, 1880. Article 15. Section 1.
Paragraph 1. Right? That's where we get that provision from. So, United States of America is obligated to the Treaty of Madrid, 1880, Article 15, Paragraph 1, which is the nationality clause for all Moors. It is the instructions on how to return back home, Dorothy. And America knows what their obligations are to Moors. And Moors have to understand what your obligations are as well. Here are instructions for the United States of America to follow, the United States International Organization, and any Moroccan state. Okay? Here we go. What are the instructions? All right. Section A. Here's the instructions.
Section A. To ensure with due respect for the culture of the peoples concerned, their political, economic, social, and educational advancement, their just treatment, and their protection against abuses.
Pause. Okay. So the United States of America is responsible for this. But so are Moroccan states. Moors have to stop blaming the colonists for all our problems. We have obligations as well to follow these instructions. What do the instructions say for people who want what? Self-governance is statehood. Okay. A, to ensure with due respect for culture of the people's concerned, Moors needed political. What's political? State. Constitution. Economic, social, and educational advancement, their just treatment, and their protection against abuses. The United States of America signed this contract. They can't abuse us. During what? Us restoring our states, getting into politics. The United States of America cannot have any interest in what goes on in Moors establishing states. That's what our treaties say, and that's what the charter says. They cannot abuse us in any form. Right? Check it out. Section B.
Section B, to develop self-government, to take due account of the political aspirations of the peoples, and to assist them in the progressive development of their free political institutions, according to the particular circumstances of each territory and its peoples and their varying stages of advancement.
Oh, you see what's happening here? Keep in mind our class today. What are we talking about today? Multilateral what? Conventions, treaties, and organizations that create a legal nature. Guess who's supposed to assist us with it? Or at the same time, guess whose obligation, who wants self-governance, guess whose responsibility is to understand this provision? Moors. Listen, Moors. To develop self-government, to take due account of the political aspirations of the peoples, and to assist them in the progressive development of their free political institutions, according to the particular circumstances of each territory and its peoples and their varying stages of advancement. So first we start off with what? Constitutions, right? That was our political aspiration. Now we're getting into what? We're starting to get into what? Political institution. What's a political institution other than your state, your three branches of government? Okay, let's go to it. Your political institutions. Where's that? Conventions. That's a political institution. Right? What else is a political institution? Any type of treaty organization we establish in our territory. This was the obligation of Moors. When did the charter come out? When was it established? 1945. We're in the year 2023. Why haven't we done this by now? More importantly, let's do it now and move forward, right? Okay. Now, going back to the charter. If we had been studying the charter, we would have understood if we wanted to develop self-government, we got to follow the instructions. Until then, we're still non-self-governing Moor subjects that have been naturalized in the United States of America. This contract's been out since 1945. Let's read section B again. To develop self-government. That's what the Moors' responsibility was to do. To take due account of the political aspirations, that's state aspirations, of the people, and to assist them in the progressive development of their free political institutions, according to their particular circumstances of each territory and its peoples and their varying stages of advancement. And that's what Moors are doing right now. We're at varying stages of advancement, right? Section C.
Section C, to further international peace and security.
Paul, so how are we furthering international peace and security? How do you further international peace and security? Well, once you have a constitution, what's next? You have to come together with your people to create what? Political institutions that create mechanisms, cooperation internally within your state amongst your own nationals, as well as figure out how to become a peace-loving state to cooperate with other states. So this is how you further international peace, is by you understanding political statehood as well as judicial settlement. How do you do both? Do you understand mediation, arbitration, and judicial settlement? So the matter can be settled, that way the whole world can get back to peace. The whole world can get back to what? Amity and commerce. The whole world is interconnected based upon commerce, and there's no commerce when there's no amity. Section D. These were responsibilities of Moors.
D, to promote constructive measures of development to encourage research and to cooperate with one another, and when and where appropriate with specialized international bodies with a view to the practical achievement of the social, economic, and scientific purposes set forth in this article.
Okay, so Section D, keep in mind, Morris, the United States of America is responsible for assisting us with this. But we also have to help ourselves. What's the acronym? Islam, I, self, law, and master. What is that we need to master? International law. That's what we need to master. Okay? Section D, to promote constructive measures of development. That's what we're doing right now. We're promoting constructive measures of development to encourage research. Isn't that what we're doing? We're encouraging research. AMPAC study session is about what? Research. Right? And to cooperate with one another. How do we cooperate with one another? Well, first, Moors have to learn how to cooperate with each other, learn our political status to come together as Erga Omnes parties through multilateral conventions and multilateral treaties and multilateral organizations to come together. Right? And the United States of America is supposed to assist us with that. And when and where appropriate, with specialized international bodies with a view to the practical achievement. What's this specialized international body? You know what that is? That's the United Nations coming in to assist more when we petition their help, because they have committees that are supposed to help indigenous people. People that are trying to establish decolonization. United Nations is designed to assist you with your human right to self-determination and self-governance. The Moors all this time have been chanting, no justice, no peace. Well, you can't have peace until you establish your own justice. How do you establish your own justice? You have to choose your own political leaders. That's how you establish justice. But instead, the Moors have been adopted by the United States of America, and we turn around and voted for the colonizers to be our rulers and leaders. And then turn around and expected them to enact legislation to uplift us. Well, that flies in the face of being a colonizer. Why would a colonizer want to uplift the very people that they have conquered? That's an oxymoron to ask them to uplift you when you're supposed to be uplifting yourself. Now, don't get me wrong. For the United States to turn around and tell, quote unquote, the black people to pull themselves up by their own bootstrap, knowing that we didn't even have a boot in the first place, well, that's just inhumane. But how do we pull our own selves up by our own bootstrap? You know what the boot represents? The Constitution. And from there, you can start to pull yourself up. You can uplift yourself with your own pen. Because the pen will put an end to colonialism. But instead, we've been asking them to use the pen to uplift us. Wrong concept. Last but not least, Section E.
E, to transmit regularly to the Secretary General for information purposes, subject to such limitation as security and constitutional considerations may require, statistical and other information of a technical nature relating to economic, social, and educational conditions in the territories for which they are respectively responsible for, other than those territories to which chapters 12 and 13 apply.
Okay, this is very important, Morris. Listen. Section E, to transmit regularly to the Secretary General for information purposes. So the United States of America signed this contract. The United States of America is responsible for doing what? Sending correspondence to the Secretary General of the United Nations to let the United Nations know these Moors have been enacting constitutions. These Moors have become acceding and becoming parties to treaties. These Moors are enacting legislation. These Moors are enforcing consular court. These Moors have put together a multilateral convention. These Moors have put together a multilateral treaty. These Moors have put together a multilateral convention. These Moors are enforcing the charter. The Moors are enforcing Resolution 1514. The Moors are enforcing Resolution 2625. The Moors are enforcing the rights of indigenous people. The Moors are no longer rising. The Moors are here. The sun is at 12 noon. And this was the responsibility of the United States of America and their intergovernmental organization, commonly known as the United States, to notify the Secretary General everything that the Moors are doing as the original inhabitants who are now operating as self-governing states because of their self-determination. But guess who else is supposed to be notifying the Secretary General based upon your varying stages of advancement? Moors. We also have an obligation to this contract to notify the Secretary General. Why is that? Because the Secretary General acts as a referee. He acts as a compliance department, the Secretariat. They keep an eye on what's going on. That way, if you have to petition for them to come in and perform an investigation, they're already aware that you put all of your documents on the record with their file. Because that's the only way they can come help you, is if you've already recognized yourself and you followed the instructions and filed everything with them through Article 102 of the Charter. Right? So why do we go through all that? That way, we start understanding what the International Court of Justice is trying to tell us through their handbook, right? Through their handbook, okay? As well as understanding what we learned about the Erga Omnes principles when we read the law review. And in that law review, started talking about documentary evidence. How can Moors prove that we have a legal nature? How can Moors prove that we are at varying stages of advancement? Well, you need documentary evidence. And the first thing they're going to look at the evidence and say, what's the name of the parties? Oh, they say they're Moorish Americans. Well, guess what? Everything they submitted is null and void. Because there ain't no such thing as Moorish Americans. Oh, they say they're Moroccans, Moroccan nationals? They got constitutions? Okay. We can check the second box now. We've identified the parties. That's what the ICJ says going to say. That's what the Secretary is going to say. That's the Secretary General going to say. We've identified the parties. They checked the first box. Let's go to the second box. Moors haven't been able to get past the first box. But what is the purpose? Listen to me. Let's understand the true purpose of why the convention in the Empire of Morocco for the Wazir Regional Council is so important for Moors. It's to help us to unite, to help us check the applicable boxes, that way we take the guessing game out of it. Moors have been guessing what they think the answer is to their liberation, to their occupation. We haven't done a good job of studying Africa and its 55 states that declared their own independence. We haven't done a good job of studying Africa who actually drafted constitutions. We haven't studied them very well, have we? So now we need to understand the instructions. So the Wazir Regional Council will help the Moors in a sincere way to check the applicable boxes so we can become Erga Omnes parties, so we can learn how to write a declaration of intervention. Now that we have a legal nature contract that brings us together, we can support each other and start to move our pieces in combination, because this is chess and not checkers, right? And chess is all about being methodical, understanding what are your next move, make your next move your best move. But all the pieces must support each other. One lone pawn can't win the game. But if you got 2 or 3 pawns supporting each other, marching down the file, that's very powerful. Even 3 little pawns, right? So this is what we must understand. We need political understanding to be competent with political prosperity. And what's the prosperity? We need to be rich in knowledge first. Rich in knowledge first. Then the money, the economics follow suit. That's the whole concept of understanding the Wazir Regional Council. These are the ones with the wisdom. Proverbs chapter 4, verse 7. It says what? Wisdom is the principal thing. So seek wisdom. And in all thy getting, get in understanding from those who have wisdom. That's what the council's about. Right? Okay, as I start to wrap up, I know that today we were going to start reading over the introduction of the intervention under international law, but we're going to save this for the next class. We'll read all 12 pages, okay? Right after that, we'll get into reading the United States Declaration of Intervention. We'll read it in real time. It's about 26 pages. We need to see what they wrote so we'll understand how to copy, paste, plug and play, because we're seeking wisdom from them. Noble Drali said to study the Europeans, and that's what we're going to do. All right, so as I start to close, up on the board, I got the Charter of the United Nations, chapter 6, about the Pacific settlement disputes. Here's the question. How can Moroccan states settle disputes with the United States of America, the United States, and any of their charter-dependent states, small case s, in the Empire of Morocco? Well, first, we have to utilize what? We got to use our consular court decrees, right? Consular court is how you settle a dispute with the United States. Okay? But when consular court does not prevail, what's next? Okay, then we have to come together as Erga Omnes parties, because they're infringing upon our integrity of domains, right? And through Erga Omnes parties, we all have to write declarations of intervention because we're obligated to do it as a legal nature through the contract that's binding between all the Moroccan states. Okay? And what's next after that? We take it directly to the International Court of Justice. And the International Court of Justice will take a look at our legal nature contracts and say, yeah, we have to allow them this class action lawsuit because they've proven the legal interest in this matter, right? And last but not least, if the International Court of Justice does not prevail, then after that, we can start to petition the International Criminal Court, as well as the other organs of the United Nations, such as the Security Council, the General Assembly, to enact different resolutions that puts sanctions on the United States international organization to start shutting down their bank accounts. Okay, that must be understood. The Security Council, the General Assembly can enact resolutions that start to potentially put sanctions on the United States international organization. So can the Moors. The Moors be able to come back from the ICJ with a win. We'll have powers and controls over certain banking mechanisms because we can enforce our treaties and we can enforce our consular courts. That must be understood. As we start to freeze the accounts of the United States, we will flank the United States. We will flank them from the inside out. From the inside, we will start to freeze the United States accounts on the sanctions. From the outside in, the United Nations has an obligation as well to deal with a belligerent state. Who's the belligerent state? The United States of America. Who's the belligerent organization? The United States, right? Two legal personalities. That must be understood. All right, so we'll get back into this in class 91. I end with that. Islam.